Welcome and thank you for joining us for this important webinar, Business Succession Planning for Transportation Organizations, presented by Sean Sullivan, Gary Carlson, Nathan Nelson. Before we begin, we'd like to thank Truck Riders, and let's advance to the next slide, please. We'd like to welcome everyone to this Truck Riders webinar series. Look for new webinars each and every month. It's sponsored by Truck Riders, which since 1983 has become one of the largest and most knowledgeable truck insurance agencies in the nation. Now, your lines have been muted for the duration of the webinar, but we encourage you to ask questions anytime in the question box. We'll try to get to those at the end of the webinar if time allows. Make sure you don't click the black X. It will close out the session. Now allow me to quickly introduce our speakers today. We have Nathan Nelson, who has graduated from Villanova University with an advanced law degree in business taxation. His practice specialties include business startups, acquisitions, dissolutions, and mergers. We also have Gary Carlson, equity partner at Lawrence Cumpston & Associates in St. Paul. He has over 30 years of experience in accounting, tax, and business consulting, and is a member of the audit committee for the Minnesota Trucking Association. With that, gentlemen, the floor is yours.
Thank you, Alan. This is Gary Carlson. A couple of items I'd like to get to in preparation for the PowerPoint presentation. One of the things I wanted to do in preparing for this seminar was to look up some various definitions of succession planning. And the one that struck me as most interesting is as follows. It says succession planning, identification and development of potential successors for key positions in an organization through a systematic evaluation process and training. Unlike replacement training, which grades an individual solely on the basis of his or her past performance, succession planning is largely predictive in judging an individual for a position he or she may never have been in. And it's the may never have been in that's, I think, the most interesting piece to the puzzle, because it's that fear of the unknown that seems to create such a difficult process for many in coming up with a succession plan. A couple of other general succession facts. There's around 10 million family-owned businesses out there. 70% of those businesses fail to survive to the second generation. 90% of those fail to survive to the third generation, which clearly indicates that there's a challenge in succession planning. One other survey that I found interesting was that in small to medium enterprises, they found that most are not adequately prepared for their business succession. Only 10% actually had a written plan, 38% had an informal, unwritten plan, the remaining 52% had no plan at all. So with that, I do recognize that everybody in the audience may individually be at different points in their own succession plans. So we'll be presenting a broad overview of concepts, opportunities, and threats that are involved in that succession planning process. We do believe it truly is a process, and sometimes it's a difficult one, as decisions made not only impact you, but also your family and the family of all of your employees. So basically today we're looking to try to develop plans that would allow a smooth transition and provide adequate value upon your exit. Today's webinar on succession planning, I hope to get you to do one of the following four things. Either get you thinking about succession planning, number two, giving you some concepts that will allow you to develop a plan, three, having you start implementation of a plan, or four, stress test, update, or review a plan that you may currently have in place. In addition, I will strongly suggest that you form early in the planning process what I call a client-centered advisory team, which should include your attorney, CPA, insurance agent, financial planner, and possibly even bankers to help guide you through this very important process. As you'll see today through our group presentation, it is very, very important to have all your key advisors on the same page throughout that process, as many of the choices involve legal, tax, financial, and risk management issues along the whole way. With that, I'm going to turn it over to Nathan Nelson, who is going to be our Teddy Bridgewater quarterback of the day, to help us walk us through this PowerPoint presentation and allow Sean and I to provide some additional comments and insight along the way. Nate?
Thank you, Gary. I think why plan is too easy of a question, but maybe what is the primary benefit of developing a succession plan is a more fair question. And without sounding too grandiose, a proper succession plan can help position a corporation to prosper currently and into perpetuity. Immediate highlights of a plan are they should place an emphasis on continuity and certainty. Continuity and certainty, two things the business environment doesn't promise us. However, if we can encourage you to adopt a plan that can hold its course through a sea of constant change, the ability to pass the interest from one generation to a next will be greatly enhanced, and that's how your corporation and your controlled group can hold the perpetuity that your articles of incorporation already provide for, most likely. What's the purpose of a business succession plan? Right off the bat, it will be the protection and preservation of the continuity of ownership into the future. Everyone should know who their shareholders are now and how can they position themselves to have the next generation of shareholders engaged. To do so, not only is it going to take finesse and buy-in, but to do it in a tax-efficient and coherent transfer of ownership process will yield dividends, and which will also spike the success ratio there. The maintenance of a strategy to address planned events, I want to stress that many of the advisors that I work with, Gary and Sean, no doubt, are always looking ahead. How can we move the ball forward? That would be a planned event, which obviously they're very skilled at developing. However, the plan should also address what I call the UFTA moment, which are a myriad of unforeseen occurrences such as an accident, divorce, death, disability, creditor claims, someone gets fired. Any of this could happen instantly, and have a plan that can provide for the planned as well as the unknown will again help continue the success of the company and the corporation into perpetuity. A team should be identified. That team, as we love to think, should start with lawyers, obviously insurance advisors, accountants, but don't forget bankers and other investors that know your assets and your wealth and your funding capabilities as well. And above and beyond all, open communication channels will have to be tested and tried and protected throughout the process. Immediately, now that if we're all taking the stepping on this webinar today, that we do think succession is of some interest, there's three primary succession entrances of a plan that we should plan for. Sean, maybe you can help us with those?
Yeah, I'd be happy to. I've actually been involved in all three types of plans. The first one would be the exit plan. It would be getting an owner out. An owner passes away, an owner is sick of the other partners, or the other partners are sick of the owner. The second one would be an entry plan. Perhaps you want to get some new blood or the kids into the company. And then finally, a capital plan. Company may be struggling a bit or sees opportunity for growth, but just doesn't have the capital to do so, and identifies someone with deeper pockets that could come on with an equity position, and that would be as a partner, and that would be the capital plan.
Well said, Sean. Let's talk about the most, I guess, fun and least controversial stage of the three, the entry of the younger generation into the corporation. What would be some of the issues that you would see that would trip the invitation of ownership from an individual into the company?
Could you run that by me one more time?
Sure. Why would you bring in a new shareholder?
New shareholder, the reason for bringing them in would be to grow the company, add some vitality to the company. Perhaps the current owners are getting long in the tooth. I guess those would be two of the reasons I could think of. Or if you had perhaps someone with some talent or that could bring customers, that would be another reason.
Sure. I've actually seen many instances where, say, a rainmaker, just a superstar employee is not only identified by his corporation, but by his competitors. And while in many instances a competitor would be very, very happy to take on your talent without getting to know them and know their ideology and their true value system, they wouldn't be so quick to offer equity interest in the company. So having been able to get to know some of your true talented employees, to be able to offer them shares and then make them part of the succession plan, that's going to give many corporations a leg up in retaining that talent as opposed to seeing it go and pass on. I think another thing that we'll see with bringing in a younger shareholder is you're going to just see a deeper buy-in into the company's mission. You're going to see that intangible statistics where freight gets delivered on time, drivers stay on, because it's not just going to be a personal agenda of the owner, but it's going to be the success of the company will be a driving force as well. Gary, with respect to bringing out a retiring shareholder, that's oftentimes something that everyone promises in 5 years. I've now practiced law for 20 years, and the same people that told me they'd be out in 5 years are still 5 years away. What have you seen to help move that along? Any tips on that?
Yeah, I think a lot of that comes down to what we're trying to do is figure out a way to get somebody out in a fashion that may be comfortable for them. One way may be to do it in a step process. We ultimately could have a situation where there's multiple lines of business going on, where we've had the owner and family develop an operating entity, maybe an entity that owns real estate, maybe another entity that owns the equipment that's being rented back to the operating equipment. One way to sort of dip your toe into it versus getting out all at the same time is possibly looking at taking yourself out of the operating company through a design succession plan, but possibly then retaining control of the leasing entity or the real estate entity. It just allows for the new transition of owners to try it out. They're going to get involved with the operating company. They're not going to be charged with having to deal with the entire operation and organization, including equipment purchasing and dealing with real estate issues. You can still contribute. So that's probably one of the first ways you can sort of step out versus just waiting and saying succession means I'm out all at once.
Gary, I think that's a very exciting first step. It does a couple things. It lets the retiring shareholders figure out what they're going to do with their days 9 to 5 if they don't have to sit over the dispatch table all day long. But secondly, it is a clear promotion to the new guard, because they're going to be the face of the operations of the company. The new guard is the one that is going to be interacting with the lenders, with the vendors, with the professionals. And so if the second step comes either unplanned or, better yet, planned, unexpected or planned, it's not going to be a surprise if it's going to be a leverage acquisition to take out the senior shareholders, or if there's going to be a call on an existing commercial note, what have you, because in the perfect world, the lenders and the vendors would be comfortable with the new guard, and at the same time, the old guard gets to hold what the true controls in transportation, cost of equipment and cost of real estate for terminals and whatnot can also drive the bottom line for an operating company. So I think that's an excellent first step. I think it also begets a topic for a potential webinar on how you should structure a company, but that's beyond the scope of what we want to do right now. Gary, I'm going to come back to you. If we're saying that we're all in for a plan, if we like the idea of bringing in new shareholders, removing old shareholders, or maybe even having to find equity in a shareholder and planning against UFTA and a planned event, how do you stay on course?
Well, I think the main thing when you start talking about creating a plan for either any one of those exit or succession plans or opportunities is that, number one, we really have to get involved with creating early communication up front. People always say, where do I start? How do I start? What I'd like to do is start with the upfront communication and make sure that there are clear roles and expectations with all the parties involved. You need strong leadership. The old guard has got to stay involved. They've got to stay excited. They've got to provide support for the new generation coming in. Probably one of the biggest aspects that also needs to be in place is that there has to be mutual respect and trust. Trust is a very crucial element involved in any sort of planning process. So once we've got the communication in place, people have started to talk about it openly and honestly, And again, spend some time here. That's not easy to do. Families don't always communicate, well. Many times you've got a situation where you're trying to get just a new person and to become an owner. So now you're working with just the dynamics of being an employee and now becoming an owner. Throw the family in the mix. Now you've got a situation where you've got three circles being involved. You're a family member, you're an employee, and you're an owner. All can create a tremendous amount of issues along the way because people may or may not speak freely. Most of the companies that I work with are family-owned companies, mom, dads, brothers and sisters, a couple crazy cousins, Mike O'Neill. Other than that, we're really looking at trying to figure out a way that once you have got through this communication steps with the proper players, you need to develop a timeline and some milestones. What Nate was speaking about is they talk and all, we get sidelined, and then nobody has set forth some real timelines and milestones that need to be monitored. And sometimes a professional such as myself, Nate, or Sean, whoever you're most comfortable with, that you think that they can help you with the communication process, you may want to have them help quarterback this and then try to hold you on task in order to keep this plan moving.
Thank you, Gary, and I agree too. I think whoever has the closest relationship with the moving parties of the corporation, that party is the one that should be on task to make certain that milestones are identified and that they're achieved in a timely manner, and that includes sharing such objectives with not only the family members or the future shareholders and the existing ones, but also the other advisors on the team. Sean, I'd like to talk to you about if we put a plan together and everything's going great. I think there's if the unfortunate event comes where we have to actually transfer shares from one generation to another, from one owner to another, one of the best ways that we've seen to solve an unexpected or an impossible to plan for scenario would be the use of insurance. Can you talk a little bit about how life insurance can be used in a succession plan?
Sure, yeah, and again, thinking back on our companies, current and past, we've used all types of life insurance and continue to do so. We use term insurance if you're funding basically for the death of an owner. The concern with term insurance is that the owner outlives the insurance policy and goes beyond the date you have to buy a new policy.
Gary, some of us would think that's a good thing. But anyway, go ahead. Sorry.
Yeah, but it can be quite expensive at that point. So you'd probably want to have an age limitation in your buy-sell agreement. The other would be a universal policy, which builds up a cash value and basically runs until the death of the owner. The nice thing about that is you can also borrow against it if you need to.
Sean, let me ask you, that same universal policy, is that something that we could solve for retirement as well with? Because term isn't going to help me on retirement. For those of you that retired, but that could, again, we would rather have a vehicle other than the cash flow of the company to satisfy the buyout of the retired shareholder. How have you addressed that?
A universal policy would definitely be better. Again, you have the cash value of that you can borrow against and pay out to the retiring shareholder, if you will, in part or in whole. If it's in part, you can basically take out a loan against yourself and pay yourself back with interest, not unlike maybe a 401k you would borrow against.
So saving the more interesting aspects of life insurance for another day, the idea would simply be a policy could be structured and owned as be a component of the succession plan that would provide the liquidity to take out the retiring shareholder.
Yes, it could.
Excellent. And then how would you solve for a key person?
Key person, you'd want to look at a universal policy. I'm sure many of you have heard the term the golden handcuffs. So if you identify a key person that perhaps you don't want to have an equity position in the company, or they're not ready for an equity position, you can set up a universal life policy, put it in a vesting schedule. So you say, if you stay with me 5, 10, 15, 20 years, we'll continue to fund that. And then at the end of that vesting schedule, they basically get the golden egg, which is the cash value of the policy, or if they pass away during the term, their family would receive the proceeds from the life policy.
Thank you, Sean. Excellent. Gary, how do you fund? How do companies? Well, who owns the policies of insurance?
Well, generally, we're talking about, this is corporate solutions we're looking for. A lot of times, the corporation is going to be the one that, on a redemption situation where we're just trying to solve for the death of a shareholder, it'd be a corporate-owned policy. The corporation's the beneficiary, and it funds all the premiums. And obviously, when the proceeds come in, we end up with having funds available to pay the deceased shareholder. The other option is you can have the individual-owned policies. Or corporate-owned policies on the shareholders. If you have multiple shareholders, and we're worrying about the death of one shareholder and having funds to provide the necessary cash flow for the redemption, we'll either do a cross-purchase with individually owned policies, or have the corporation again own the policies and provide the coverage there. Again,
how do you fund a cross-purchase?
I would do it, via corporate assets again. Budget for the corporation being the vehicle to fund the premiums. If it needs to go to the shareholder, we have to run it through as W-2 compensation. At that point, again, it may be deductible at the corporation at that level, but it's not deductible by the shareholder.
So basically, what you're sharing, whether it's a cross-purchase or whether it's a corporate-owned policy through a redemption vehicle, the corporation will be the ultimate payer of the premium. And are there any tax benefits to that? Does anyone get a deduction here generally?
No, there's really no tax deduction for insurance premiums, as we ultimately would like the proceeds to be non-taxable upon the policy being taken care of.
So then, to your point, most companies would budget for the insurance premiums and then pay the premiums out of cash flow.
Yes.
Okay. Well, very well. What we've seen here is we've talked about a plan, but we haven't actually talked about the mechanics of a plan, if you will. And what they could take many forms. Many times, lawyers would be the ones that would actually assist in drafting the plan, but hopefully getting the insight from the other team of professionals as well. What I'm talking about is a buy-sell agreement, a shareholder control agreement, or a buy-sell and a shareholder control agreement. In simplest terms, we're talking about the rule book for one or two things. We're talking about the rule book for the transfer of shares, or we're talking about the rule book for the management of the company. Many times this process can involve both of those tools, but to keep it simple for today, I want to focus on the transfer of shares. And many corporations come to Gary and Sean and I to make certain that the shareholders are the present group and not spouses, not competitors, not creditors of the corporations. So what we'll generally provide is that the shares of stock in a corporation are not going to be transferable without the consent of other shareholders. And even if the consent is not if consent is not attained by other shareholders, then a vehicle would to intercept any transfer of corporation shares would basically be a right of first refusal. Oftentimes we have the corporation, because we'd rather use the corporation's money to intercept the transfer, would have the first opportunity to buy shares. Other times, if the corporation were to pass, existing shareholders would have the second opportunity to intercept a transfer of shares that was not consented to by the other shareholders of the corporation. In that fashion, there can be no surprise transfer of shares. Unfortunately, many times a surprise transfer of shares, be it a divorce or a creditor or a very disgruntled employee owner, could come at the world's worst time from a cash flow perspective for the corporation. Get off the sinking ship, if you will, liquidate now, whether it's a corporate issue or it's the shareholder's own issue. So what we would provide for, in addition, would be timing for the corporation to pay back the purchase price. So a vehicle will be determined how the purchase price is determined, and then a means to provide timing, like a promissory note over so many years at an interest rate that everyone agrees to now while they're all getting along, would control the payment of the transferred shares, or better yet, the intercepted shares. The buy-sell agreement is going to have general restrictions against the free transferability of shares. It's going to require the consent of the other shareholders to be engaged to transfer the actual shares. It's going to provide a right of first refusal to intercept any in an unintended or unplanned transfer. It also would have a poison pill in many cases where, God forbid, a creditor got a hold of the shares. We could see many instances where the corporation could intercept the transfer to the creditor for a greatly reduced price, maybe as low as even 50% of the value of those shares, or even less than that. The reason is because a discount would be warranted because we didn't plan for it. It came out of surprise. We had no control. We didn't cause it. There should be a discount because the shares aren't going to have voting privileges. And it's a big disruption. It's going to create financing charges on the company to service the payments of the redemption. It's going to cost legal fees because we're going to be fighting it. And it's going to be a big disruption that could cause an interruption to the business of the companies. So we would generally put a poison pill to that effect into any of our shareholder control or buy-sell agreements as well. Having said all that, I think that concludes the primary portion of the webinar today. Were there any questions?
There are. Let's move to the Q&A slide, please. And several questions have come in, and we encourage other people to ask them. We have a few minutes for these. Let's tackle perhaps the most nuanced question first. My parents gave me stock in the family business representing 20% of outstanding shares. We don't have any shareholder meetings. I'm never provided an opportunity to vote or to contribute. We have no buy-sell agreement. The business has value, but I'm not receiving distributions, can measure it with what I think I should. What are my rights?
Well, you generally have no rights to make the company buy back your shares. That's usually what a lot of disgruntled shareholders want. They see an equity value on the company and they just want it realized. You're a passive shareholder. There is not a publicly traded stock. There's not a big market for it. So the short answer is you have no direct rights for redemption of your shares. However, again, a disgruntled shareholder may look to other means to liquidate those shares. And without any protections at the corporate level, and as the way you described the scenario, the stock is unrestricted, that shareholder could sell to any other person or entity. We've already determined that the market may be very small or even non-existent for non-controlling stock in a family business. But if you were to sell it to a partnership, a disqualified entity, or even a competitor at a fire sale, the results could be drastic to the business. The disgruntled shareholder is going to get liquidity, but pass-through tax elections could be lost to the corporation, or worse, strangers, competitors, could have access to all the books and records, not to mention several other statutory rights of shareholders that may be asserted, effectively distracting or preventing the company from focusing on its business or controlling who its owners are.
Very good, thank you. We have time for one more. There's several questions of this type. I am the sole owner, officer, and director of my company. I have 15 employees. I have no succession plan or estate plan in place. What happens if I become disabled?
The company's in danger. I could say grave danger, but you didn't say the person was terminal. No person would be empowered to act on behalf of the company as an officer. We very often see, I'm the sole director, I'm the sole officer. Well, now we have no man, and I'm the sole shareholder. So a conservatorship would have to be commenced to first determine the incapacity of the person. They might be going kicking and screaming. We might all know Fred's incapacitated, but maybe Fred's contesting that, if you will. Fred, of course, being a fictional character. So that's going to be one fight. The next is going to be the determination of who the conservator would be, assuming that the owner is in fact incapacitated. Next, these determinations are not provided for who would make that decision. So it'll be a county judge. It could be the very worst of all worlds, the product of compromise and this could lead to the rudderless control of the company. If the company is subject to commercial lenders, defaults could be tripped and financing may be jeopardized. The ultimate person appointed as your conservator would either appoint a board or hire a president, but that doesn't mean the other advisors will respect them, or if notes and obligations won't be called, or if vendors won't turn away.
Well, thank you very much. We're right about at 30 minutes now. The information is available on your screen. Sean Sullivan, 763-785-0500. Sean at truckriders.com. If you'd like additional information on this subject or on other trucking insurance topics, please reach out to him. We'd like to thank our excellent speakers today. This was a tremendously educational webinar. Look for new webinars from Truck Riders in the very near future. We thank you all for joining us today and hope you have a great day. This web seminar is now ending.